Yo, YouTube, what it do? What it do, man? I'm back with another video. Y'all know I really don't. I think I did one video on this one and one video on Thug like a long time ago, but I really don't touch on to this like type of stuff too much because it's just like shit. Niggas might not follow my opinion. I'ma always keep it 1,000. And free Melly. That's what I gotta say. Cause me personally, I don't think he did it. I think he know what went on, or like he got a clue what went on. But me personally, I don't think he did it. So I really don't think he should be locked up, or they shouldn't be doing him the way they is doing him. But that's just my personal opinion. Don't hate me for my personal opinion. That's just how I look at it, and I look at shit a whole lot different than a lot of motherfuckers. Ooh, a lot of people. So Cuff Boys. I like bro. He up to date with a lot of stuff. The YMW Melly trial just changed in Melly's favor.
The YNW Melly murder trial just completely changed. The court has filed an omnibus order on the defense motions to suppress and actually grant some of them. Melly's team was trying to throw out the evidence of his phone, his emails, his Twitters, his Snapchat, his Facebooks, his Google accounts. Right. And it seemed like it was kind of a Hail Mary to just get rid of it, but it actually worked in his favor, and the judge is getting rid of only stuff that's in the time frame of the murders. This is a giant W for Melly.
Stuff that's in the time frame of the murders?
Into this. I'm gonna read it all. Here we go.
How does that work?
All right, first thing we got right here is speedy waived by defendant, trial to begin March 5th. So the trial is delayed to March 5th now officially. I have a feeling it could be delayed even more, to be honest. Second thing we got here is defendant's motion to strike state supplemental discovery. Defense motion filed December 14th is hereby denied for reasons as stated on the record without making any finding as to the potential admissibility of the evidence. Signed by the judge on December 18th. Now here's a very, very important document. We have an omnibus order on defense motion to suppress 1 through 13. So motion to suppress, number 1, motion to suppress evidence, search warrant requiring disclosure, communications and electric storage and electric systems for 180 days or less on Melly's phone number right here. And the second motion to suppress right here is Melly's Twitter account. Third motion to suppress is the iCloud of the phone number. That was Melly's. Fourth is motion to suppress search warrant for Melly's Snapchat. Fifth is the Google. So I would imagine that's emails and whatnot. Motion to suppress evidence based upon illegal search and seizure. Search warrant on January 8th, 2019 on the Facebooks. Motion to suppress number 7 is his Instagram. Motion to suppress number 8 is the cell site location data and all that bullshit. Motion to suppress number 10, amended motion to suppress evidence seized pursuant to warrant issued by Judge Olera in reference to Apple iPhone X. Motion to suppress number 11 is another Apple iPhone X. Motion to suppress number 12 is Google accounts of YNW Melly Hunter K Management and YNW Melly Booking. Motion to suppress evidence seized and obtained through YNW Melly Booking at Gmail. The state filed an omnibus response on November 6, 2023. The court held a hearing on defense motions and heard testimony from Assistant State Attorney Michelle Boutros and Miramar Police Department Detective Mark Moretti. Having considered the defense motions, the state's omnibus response, the evidence presented, arguments of counsel, the court file, applicable law, and otherwise being fully advised, this court finds as follows. Franks versus Delaware, they cite. Okay. Defendant argues that all the evidence found pursuant to the 13 search warrants that were issued based on Moretti's search warrant affidavits should be suppressed because the affidavits include deliberate falsehoods or omissions. The movement is required to point out the specific portion of the affidavit alleged to be defective. Okay. Although the court agreed to hear testimony from Moretti and Boutros, defendant did not move for a Franks hearing, nor did the court grant one. Defendant failed to establish that he is entitled to Franks hearing, that any alleged falsehoods, omissions, or misrepresentations resulted from intentional or reckless police conduct, or that deliberate falsehoods, omissions, and misrepresentations would have affected the magistrate's probable cause determination as to any of the search warrants at issue in this order. Alright, so now they're about to go through each of the motions, 1 through 13 right here, and the judge is going to either grant them or deny them. Court finds search warrant for T-Mobile to provide historical wire electronic communications for Melly's phone number 9807 is supported by probable cause, so granting that one. It is clear the defendant's physical location would be germane to finding the location of the crime scene and determining his role in the shooting. The affidavit certainly could have better explained the connection between defendant's physical location and the historical cell site data stored by T-Mobile. However, evaluating search warrant applications, judges may consider what is or should be common knowledge. So yeah, that was the argument for the first one, was just that Moretti didn't add a lot of things that could be considered common knowledge to police officers versus someone that's not a police officer. But this is just Melly's lawyer like nitpicking stuff. So motion to suppress number 1 is obviously denied. There's suppress number 2 on the Twitter account. Court finds the search warrant for data from the defendant's Twitter account is supported by probable cause, with the exception of all past searches saved by the account for which there is no probable cause. Ooh, so they're going to start pinpointing shit, because this prosecutor likes to, they had big dumps of everything. They had 400,000 pages of Facebook or whatever. Affidavit states defendant and associates identified as blood gang associates and that they were feuding with another gang from North Broward area. Okay. Moretti also read messages on Twitter from users claiming responsibility for the murder which tagged defendant's Twitter account, including users affiliated with rival gangs. Based on the above, there was probable cause to believe a further search of defendant's Twitter account within the specified 1-month time period would reveal further information. However, the portion of the warrant authorizing a search of the records of past Twitter searches outside of the specified date range is not supported by probable cause. Any evidence found pursuant to this particular provision must be suppressed. Number 2, granted and in part denied. Bro, that's actually kind of a W. They're getting rid of the unnecessary Twitter searches. All right, number 3, the iCloud. The court finds that while some of the provisions of the search warrant are supported by probable cause with the addition of temporal limitation, it is clear from the search warrant affidavit that the defendant's physical location and shortly after the homicide is vital importance. Police officers had reason to believe the occupants of the vehicle were on the phone at the time of the shooting. The defendant had called his mother just after the shooting. The defendant's phone was in use and communicating with cell towers around the time of the shooting. Once again, Moretti could have better explained the connection between iCloud storage and the defendant's cell phone. However, it is common knowledge that the iPhones will back up to iCloud unless the user has turned off iCloud backup. Based on the 4 corners of the affidavit, there's probable cause to search the defendant's iCloud account for the evidence of the defendant's location during the shooting and for the evidence of any forms of communication. The search warrant authorized a much broader search than was reasonably given the facts in the affidavit supporting the warrant. Okay, so they're going to start denying a lot of the broader searches, which is kind of funny because I remember Melly's lawyers being really upset about that during the first trial. That there was a lot of broader searches and that they only should have really done October and November maybe of, right around the shootings, but not, years of searches. The lack of any temporal limitations in the search warrant is highly concerning given that the iCloud accounts contain an enormous amount of data, not just from the purchase of a particular iPhone, but from the inception of the Apple ID. Damn. This search warrant essentially gave Moretti unfettered access to a lifetime's worth of private emails, text messages, photographs, videos, and documents. That's kind of wild, dude. Isn't that excessive as fuck? Like, let's be honest here. If you're, you think Melly's guilty, still kind of sketchy that they did his whole life of Apple ID. Search warrants should be limited to the time period the affidavit suggested. Moretti could not in good faith believe it was reasonable to search the entirety of defendant's iCloud account for evidence limited to a span of less than 24 hours. Common sense dictates Moretti did not need to search through everything on defendant's iCloud account to look for evidence of his location and communications with others on the morning of the homicides. Only evidence found pursuant to the following provisions of the search warrant are admissible: subscriber information, photo stream records, and videos from 3 a.m. to 9 a.m., so only a 6-hour window. Backup of all the data such as text messages, GPS from 3 a.m. to 9 a.m. Voice memos, notes. Bro, wait, what? Bro, they're getting rid of a lot of the messages that they read in the first trial. What? This is crazy. Bro, they're getting rid of everything. This is crazy. Emails to include but not limited to email addresses between 3 a.m. to 9 a.m., dude. Wait, I'm actually shocked right now. I did not think the judge would do all this. Find my iPhone data only from 3 a.m. to 9 a.m. What? Granted and denied in part. Holy shit. All right, the next thing is the Snapchat. Bro, that is big for Melly right here. Like, these are big W's. Although the search warrant affidavit provides probable cause to search the defendant's Snapchat account for his evidence of whereabouts and communications, it is temporally overbroad. Here we go again. They're not going to like all the shit that they got from his Snapchat, dude. This is huge for Melly's team. Low key. Search warrant affidavit establishes the defendant was communicating on the morning on Snapchat. The Snapchat search warrant does include a range from October 1st to November 25th. However, based on a review, inconsistencies in the various warrants, and based on Moretti's testimony, this data range seems arbitrary. The court cannot find that Moretti relied on the temporal overbroad search warrant in good faith. When questioned about temporal limitations in the search warrant, it became clear that Moretti relied on the subject belief that this was a reasonable time frame rather than any other objective case-specific reasons for the broader time frame. Damn. Based on the above, the only Snapchat records found within a time period from 3 a.m. to 9 a.m. shall be admissible at trial. Bro. This is really pinpointing the time period down, dude. They can't read all this bullshit for days on end like they did in the last trial. Remember, they have to prove Melly was in a gang, and a lot of those messages were outside of the time frame. Like, think about that. Now, the Google accounts. Search warrant affidavit provides sufficient probable cause for the issuance of the Google search warrant for GPS and other location history data between the hours of 3:50 and 4:35. So that one's denied. Now, the Facebook.
If y'all watch the trial, I think that judge is like really like even though he's Caucasian, that judge was really like, he wasn't being biased. Like some stuff was like, and then some stuff was like, all right, cool. You really not being biased, like you really just trying. But then again, it all has to fall on the jury. Like it got to fall on random people. That's the fucked up part about it too. So it's like the judge only could do so much, even though I don't think he did it.
Some provisions of the Facebook warrant with added temporal limitations are supported by probable cause in the search warrant. There's no nexus for the other provisions, which must be severed from the valid portions of the search warrant. So here we go again. The Facebook was excessive. It was like 400,000 pages or something crazy. The affidavit ends with Moretti speculating that because people generally share personal information with one another on Facebook, giving a glimpse into their private lives, this warrant will assist in obtaining additional information to further the criminal investigation. However, the search warrant affidavit contains no temporal limitations, which appears to have been an oversight on Moretti's part. As previously discussed, the court does not find that Moretti could have relied on such temporally overbroad warrant in good faith. Therefore, this court finds it is necessary to sever the temporally overbroad portions of the search warrant and suppress all evidence outside the date range of October 26th to January 8th. Order granted and denied in part. Dude, they're getting rid of a lot of the messages that Melly had with other people. A lot. All right, so now the Instagram account. This is big. The Instagram search warrant is also temporarily overbroad, and the court must sever the portions of the search warrant. Here we go again, boys. So the Instagram search warrant is from October 1st to January 15th, 2019. Since the search warrant affidavit only provides probable cause to search the defense Instagram after the homicides occurred, there's no nexus between the homicides and any prior Instagram records. Any evidence before the date of the murders shall be suppressed. That's big. There was a lot of messages with Melly and other people before the murders, bro, that they showed. Like, think about that. All right, so now the T-Mobile records of cell site location. Defendant has not specified what evidence was seized pursuant to this warrant. Since the purpose of this warrant was to track defendant's real-time whereabouts once the police had ascertained that he was a suspect, it is unclear what, if any, evidence was obtained pursuant to this warrant. So they denied that one because his lawyers weren't specific enough. All right, so now the T-Mobile warrant. So that's different from the cell site location. That one's also denied. Historical cell site information for the defense phone for the month preceding the homicides. Moretti testified that he did not find any relevant evidence pursuant to this search. Oh, so it didn't matter anyway. So they're just saying there was no evidence found anyway. So that specific one at least. And the Apple iPhone X is also denied. And then the second Apple iPhone X apparently isn't, I don't think. The search warrant affidavit provides probable cause to search to seize only a minute fraction of the incredibly vast number of records. Therefore, any evidence seized pursuant to invalid portion of the search warrant must be suppressed. Moretti testified in court they need the access to the entirety of the data and records on the defense cell phone to establish a pattern of life. Although he does not include this rationale in the search warrant, he did seek authorization to search any files or data contained on the seized items and electronic storage media that show the ownership or control over the seized items. So basically trying to prove that it was Melly's phone. The state also does not account for why law enforcement cannot limit the scope of their search of broad categories of data and records, even though it is necessary to first seize these broad categories by downloading the contents of the cell phone. Okay. Therefore, only data and records created between October 26th and February 13th when defendant was arrested will be admissible at trial. All evidence found outside of these perimeters shall be suppressed. Dude. They showed a lot of stuff before the murders, if you remember in the first trial. Yeah, and they're getting rid of all of it. This is crazy. I didn't even know about this. All right, so now the emails.
I watched a lot of the first trial.
Affidavit provides probable cause to believe evidence of the defense location on the morning of the homicides will be found in Google user accounts. However, the search warrant is too broad because it's from October 1st to November 1st. Okay. Any records before the 26th shall be suppressed. All records created between October 26th and November 1st shall be admissible. Granted and denied in part. All right, so now the Melly booking email. The affidavit establishes the defendant committed the homicides and that the defendant is affiliated with a gang. However, gang affiliation without more is not evidence that the defendant committed the homicides. The search warrant affidavit contains nothing to indicate that the homicides were gang-related. While it would be rank speculation to conclude that the homicides were gang-related merely because the defendant is alleged to have gang affiliations, the search warrant affidavit does not even include such conclusion and merely states that the grand jury, which returned the February 23rd, 2022 superseding indictment, heard evidence of defense gang membership. The court finds that there's no substantial basis for concluding that there was probable cause to believe that the evidence of the homicides would be found in the search warrant of defense Google user account, even if text messages did provide a minimal nexus. These text messages were sent on September 7th, 2018. These text messages were found after an impermissible search of a portion's defendant's cell phone records. When the text messages, which are fruit of the poisonous tree, are excised from the affidavit, there was no substantial basis to find that the Google user account would contain evidence of the homicides. It is hereby ordered and adjudged the defense motion to suppress number 13 is granted. So I'm pretty sure this includes all the blood emails that they found in that YNW Melly booking email, where all the blood people were messaging him. They just got rid of all of it. it. How the
Damn.
fuck is the state gonna prove that he's a gang member without that? Like, that was a big chunk of how
think
they're gonna
that's
get
like
the death
if-
penalty, because they have to prove
yeah,
he's a
he's
gang
saying-
member,
he's
and this
saying-
was like a gang kill.
So if it was a gang killing, he was gonna get the death penalty, right? So the death penalty is kind of like off the charges, because you gotta confirm like the hand signs and shit don't mean nothing. Like the rap really don't mean nothing, but like you gotta confirm that he was a gang member. So if you could confirm it was a gang killing, that was gonna give him death penalty. But
Killing, remember? So this is fucking crazy. This just changed the whole game, boys.
No cap.
I don't know why I didn't know about this, because this all happened, I think, right before Christmas. Yeah, 5 days before
damn,
Christmas.
I'm late.
I'm late on this, but I just
too,
read it for
brother.
you guys. Getting rid of a lot of the stuff before the murders for Melly. So yeah, comment down below what you guys think. Fucking love you guys. See you in the next video. Peace out.
Motive anyway. This man said definitely life without parole is crazy. Good for the judge and got Melly. Fair trials are important. Thank you. It's gonna be a fair trial, no cap. But I really, I'm older. So many trials at one time. I can't keep up. No cap, man. Everybody seems like they just getting locked up, bro. Why you stay out of the way? But nah, yeah. Guess a little Melly update, because YouTube there right now. I can't find nothing to react to. You know what I'm saying? So like, comment, subscribe, run the lights up. If you're new, like, comment, or subscribe. Don't let that go over your head. And yeah, I'm out. Get it.